Okay. Sorry, we're making sure we were all working technically. So welcome to the afternoon panel of the James Madison Program's Institutional Neutrality and the Mission of the University Conference. I'm Keith Whittington, the William Nelson Cromwell Professor of Politics here at Princeton. I co-direct the Initiative on Freedom of Thought, Inquiry, and Expression with Professor Bernie Hagel. We're really pleased to be able to put on this panel. The first session this morning was, I thought, very informative and interesting. I'm hopeful that this afternoon session will also be. It's loosely, I think, organized around the theme of legal implications of the Kalven Report. I was struck doing some research relating to the Kalven Report recently. Went back and was perusing issues of the student newspaper at the University of Chicago in the year the Kalven Report was issued, figuring there'd be a lot of discussion in the student paper about the circumstances that led to the creation of the Kalven Report and its reception on campus. And I was surprised to see that the Kalven Report got hardly any attention in the student paper at the time, even though it's subsequently become an important touchstone for thinking about institutional neutrality issues and academic freedom issues on university campuses. But instead, I discovered that Harry Kalven also chaired another committee that year on student discipline. And that committee got lots of attention from the student paper. That turned out to be the far more controversial committee from the students' perspective and from the university's perspective than his committee on institutional neutrality. So you never know where your place in history might lie. I should note as well that this is being live streamed, and you can find us online at mediacentrallive.princeton.edu if one were to want to check that out. So let me introduce you to our panelists for this afternoon's session. And we'll just go down the line, and they will come up here to the lectern in order to deliver their remarks. Hopefully they'll pick up a little better as well for the live stream in particular. So first up will be John Tomasi. He's the inaugural president of Heterodox Academy. Before joining the Heterodox Academy, he was the Romeo Elton 1843 Professor of Natural Theology at Brown University, where he taught political philosophy, ran a very significant and successful political theory project there as a independent research center on that campus before taking on this more public relating important role at Heterodox. Next to him is Paul Clement. He is a partner at Clement and Murphy, PLC. He served as the 43rd Solicitor General of the United States from June 2005 until June 2008. He has a very robust practice as a Supreme Court litigator. He's argued over 100 cases before the United States Supreme Court, including a number of important First Amendment cases, including those that intersect with academia and education. Next up will be Rosemarie Monge, who is an associate professor in the Department of Ethics and Business Law at the University of St. Thomas in Minnesota. She has her PhD in Ethics and Legal Studies from Wharton School down the road at the University of Pennsylvania. Her expertise focusing on business ethics in particular. And finally, Nadine Strossen, who is a senior fellow of the Foundation for Individual Rights and Expression, previously known as the Foundation for Individual Rights and Education, but still with the same acronym of FIRE. She is the New York Law School professor emeritus and a past president of the American Civil Liberties Union from 1991 to 2008. And as a consequence has been deeply involved in a wide range of civil liberties issues over time, including free speech and First Amendment issues and issues associated with education have been quite central to her interest of late. So let me turn it over to them, and then we will open it up for questions and comments. John.
Thank you, Keith. I just want to say that I'm really grateful to the James Madison Program for organizing this event and the series of which it's a part. and also for including me. So thank you so much. On the train from New York, I read an article that was recently published by Princetonians for free speech. The article's title was Harry Kalven, Institutional Neutrality, and the Charisma of the First Amendment. I found the author, I believe, is in the room. I found it an edgy but highly thoughtful piece, and I most strongly recommend it to you. Still, this article contained the following statement, and I quote, "Whereas the Chicago principles articulate what a university ought to allow, the Kalven Report articulates what a university should forbid." This is a familiar account of the relation of Kalven to the Chicago principles. I've heard similar accounts sort of running beneath the conversations this morning. Allow me to say, I doubt it. Or at least, I would like to invite you to scrutinize that conception of the relationship between these two documents with me. Correctly read, and so here's my suggestion to you. Correctly read, the Kalven Report, far from simply forbidding action, more often positively requires that universities, quote, take collective action on the issues of the day. What's more, I suggest, this requirement that universities speak and act does not apply merely regarding non-controversial issues. Far from it. Indeed, the issues in which the Kalven Report requires that universities take collective action are among the most controversial issues of the day. I say this because there are historical periods, such as ours at this moment, when taking collective action is the only way the university can protect, quote, the conditions for its existence and effectiveness. Put another way, there are times when an institution committed to toleration and neutrality must speak out and indeed must act in defense of those very values. If institutional neutrality is based on an ideal of the university as a community for the pursuit of knowledge, a premise of Kalven, and if the idea of knowledge seeking is itself under attack, the university can only defend itself by responding to that critique of the ideal that is its basis, its foundation, its raison d'etre, its very self. This is an approach, what I'm going to suggest, that respects formal rules but does not worship them. It's an approach that, along with respecting rules, takes culture seriously. It's an approach that looks out for first things and that is serious enough and committed enough to name those things and to insist that they be defended. But then, to paraphrase a friend, when the university speaks, what should it say? Kalven, I believe, can guide us. According to Kalven, the university should refrain from exercising its expressive capacities, except to counter threats to its core mission as a knowledge-seeking institution. And I'll just read from that key paragraph, paragraph 9, the first two sentences. From time to time, instances will arise in which the society or segments of it threaten the very mission of the university and its values of free inquiry. In such a crisis, it becomes the obligation of the university as an institution to oppose such measures and to actively defend its interests and values. To the writers of the report, and perhaps to most readers since, it seemed natural to think of the Kalven Clause, as I'll call that from now on, the Kalven Clause. It has seemed natural to think of the Kalven Clause as applying first and foremost to threats that arise external to the university. Indeed, every example given in the report, paragraph 2, are examples of this type. For example, they talk about the Broyles Bill, the Jenner Committee hearings, and the selective service requirements. And it's easy to imagine contemporary examples of this same external type. An American president, let's imagine, who for cynical political reasons, and this is a thought experiment, by the way, these cases can be read in different ways. Imagine a president who for cynical reasons advocates a ban on visas from some large category of foreign countries, thus dramatically restricting the pool of talented foreign students and researchers on campus. Or imagine a group of senators peddling a proposal to impose, let's imagine, very steeply progressive taxes on university endowments. They're coming for you, Princeton. The Kalven Clause says, these external movements are threats to our mission as a knowledge-seeking institutions. The university leadership, Kalven Clause requires, must speak out. Today, however, the most serious, indeed I suspect, the most existential threats to the traditional mission of the university arise not from without, but from within the university itself. This is going to complicate things, and it's going to complicate our reading of Kalven. Some of these threats, but not all of them, by the way, arise in the form of ideas. Consider, for example, the postmodern idea that there is no such thing as truth or knowledge, and thus to define the mission of the university as a pursuit of knowledge or truth is simply to place one illusion atop another, like a child's wobbly tower of blocks. Or consider the Marcusean idea from 1965 that appeals to neutrality or toleration of difference are mere masks for power, devices by which the strong disguise their structural domination of the weak. Or, more recently, consider the idea that free speech is a sign of white fragility, and therefore the defense of open inquiry, once a sigil of university life, is in fact white supremacism without the hood. The beleaguered doctrine of free speech requires that the university must allow space for such viewpoints to be expressed. Indeed, when they are expressed with sophistication and with clarity and sincerity, they help push forward the frontiers of understanding. My own view is that a great university should actively recruit and support the very best critics of open inquiry and of toleration too, just as it should recruit and support the very best defenders of those ideals. Now, it's possible that upon hearing these critiques voiced on their own campus, the university leadership of some school will become convinced. They will become converts to the idea that knowledge is nothing, that toleration is domination, and that appeals to free speech is racism in thin disguise. And this conversion, let's imagine, might not merely be something that these leaders feel personally in the privacy of their homes, but rather something that they accept. They accept the radical critique as in their institutional capacity of leaders, as leaders of this institution or some institution, and they review the critique as a roadmap for radical institutional change. A little aside, if I may, some of you may be aware that 2 years ago at Brown, a group of students and some faculty produced a book, widely known as the Brown book, which was a roadmap to radical institutional change at Brown, which talked about the various structures that hold the power that hold it up, how to identify them, how to attack them, how to change the university in a dramatic way. I just mentioned that. There's similar books at other schools too, by the way, including Princeton. In this case, a case such as the one I'm describing, where a president thinks this way, the Kalven Report and the Chicago Principles, and the idea of the university as a place for the common pursuit of knowledge are all out the window and in the ditch. What to do with those endowments now? But in the happier case, where more tolerant, more caring, more reasonable, and more serious minds prevail, the university, while providing a home to all these critiques, will continue to understand itself as a knowledge-seeking institution. It will continue to believe in the possibility of knowledge and to believe that open inquiry and free discussions gives humans, in all our perfection, their best chance to approach it. In this case, what does the Kalven Clause counsel today? On the expressive dimension that I've been focusing on for time constraints, on the expressive dimension, the Kalven Clause says that the leadership of a university must speak explicitly and loudly to defend their mission as a knowledge-seeking institution. And they must do so against all manners of threats and challenges to that conception, external and internal as well. And even the internal ones are closer to the heart, and thus, to some degree, perhaps more threatening, more dangerous. This expressive narrative, this expressive imperative applies not just to university presidents, I believe. It also applies to department heads, to center directors, and to deans of admission, orientation, and student life too. So I'm suggesting that the Kalven Clause, that line, paragraph 9, sentences 1 and 2, the Kalven Clause requires that university leaders must take a side in their institutional capacity. And yes, here we go, and yes, on this expressive dimension, such statements on the part of university leaders may have the practical effect of chilling dissent of a certain sort. To be true to Kalven, this effect, I think, might well be seen to be a predictable but acceptable cost of university leaders adopting the more active and muscular attitude in their speech and in their policies. Of course, the wider lessons of the Kalven Report apply to the Kalven Clause too, and we must own up to them honestly. If we're allowing and encouraging the critics on the campus, and yet the structure of the university requires that a president speak to support the structures that are being criticized, how does that affect the critics? I suspect it chills them. I suspect it may have a deleterious effect on some of their activities. Or perhaps more optimistically, it may have a morphological effect in their critique that I could talk about if you're interested. I'll close with this. There are other internal threats to the university's interests and values besides the ones I just mentioned, besides the expressive ones. These threats are equally, if not more existential than the ideas that I mentioned. They're not exactly expressive, nor are they quite corporate. I'm thinking of the institutional structures that condition the lived experiences of students and faculty on campus. And they do so, these structural features do so in ways that undermine the ability of universities, to pursue their mission of pursuing truth and disseminating knowledge. I'm thinking of things like the implicit bias within admissions criteria, a huge problem, I think. The dearth of ideological and viewpoint diversity, including religious viewpoint diversity, within the student body, and more alarmingly, of course, the professoriate. The biases within hiring and promotion, including the structural implicit biases within practices of journalistic blind review, so-called blind review. And familiar things, orientation programs, offices of student life expanding in the way they do. I think these structural problems pose as much of a challenge to us achieving our ideal of being a knowledge-seeking community as the ideas that I mentioned before, perhaps even more so. Imagine a university that set itself the task of expunging these problems, these challenges to diversity. So they expunge bias from their application process. They prune the trees of student life, making them bonsais, let's say. They address the pipeline problem when recruiting and mentoring graduate students. They seek at every turn to improve the culture of teaching and research so as to realize the values of open inquiry, viewpoint diversity, and constructive disagreement, the core values of Heterodox Academy, by the way. A university undertaking all these positive social actions, I suggest, might also find itself blessed and indeed anointed by the Kalven Clause. Thanks.
So it's a pleasure to be with you this afternoon. I think I'm a little bit of a departure from some of the speakers, at least this morning, because I don't spend my days in academia. I spend my days arguing in front of a very textualist Supreme Court. And so perhaps as a result, it was inevitable that I would take the title of this afternoon's session quite literally and look for the legal implications of the Kalven Report. And so I'll start with what to me is the most kind of obvious legal implication of the Kalven Report, which is that in the context of a non-public university, there aren't a lot of direct legal implications because you don't have the key ingredient you need for a First Amendment issue, which is state action. And I think that's just a useful observation because I think that what you're dealing with in the context of most of the universities, certainly the University of Chicago, you're talking about First Amendment values. You're not talking about legal doctrine as such. And that, I think, doesn't mean that the First Amendment precedents of the Supreme Court and the like aren't relevant, but it does mean that they apply by extension or extrapolation. They don't apply directly. And to me, this is an important point because in a lot of contexts, people loosely talk about censorship. And I think at least as far as the First Amendment's concerned, it's really distinctly focused on when the government sort of makes the censoring decisions. So I think I'm a huge fan of the Kalven Report, but I wouldn't want it imposed by the government. That, to me, is a starting point. So then there's another sort of legal doctrine that leads to me to sort of an interesting question that I think has been sort of suggested in a lot of this morning's remarks, but maybe not expressly, which is, do you need the Kalven Report to have the Chicago principles, or are these sort of two independent things? And I'll offer you the observation that as a lawyer looking at this more of a generalist, I would say they actually are independent. And the reason I guess that conclusion comes naturally to me is I'm very familiar and comfortable with the notion that the government has to allow free speech. It cannot, I mean, there are lots of doctrines and exceptions, but as a general matter, the government has to allow the citizenry free speech, but the government is entitled to engage in its own speech, so-called government speech. And as to government speech, it doesn't have to be neutral. It doesn't have to be, it can discriminate on the basis of viewpoint, content-based, anything else it wants. All the things that it can't do when the government acts as regulators, it generally can do when it's speaking in its own name. And so to me, the same logical principle applies, which is to say, you can have a university that's very committed to free speech principles of the professorate, of the students, but not necessarily ascribe to the Kalven Report. You could essentially try to have it both ways, if you will. And I think people implicitly conceded that in this morning's discussion with talking about a sectarian university or other universities that have sort of a distinct mission that allows them to essentially express their own views that are distinct and in this corporate way that the Kalven Report would shy you away from. It affirmatively embraces that. It's part of the university's mission. But I think some of the same universities, if they want to, can allow for academic freedom. And I think you see this. I'm also a product of a Jesuit education. The Jesuits have a mission, but I think that the Jesuits at a lot of their institutions, all but encourage criticism of the Jesuits. So I don't think they necessarily go hand in hand. And I think then that's important because then if you think about this through a legal framework, the Kalven Report is not compelled in any way, shape, or form. It is a choice. It is, in a sense, almost a remarkable act of self-restraint. Because as far as the law looks at this, as far as we think about this in like traditional First Amendment principles, a private university is perfectly entitled to speak as a corporate entity in its own name about any controversy it wants. And so this whole idea of not speaking in that corporate responsibility is an exercise, kind of a remarkable exercise in self-restraint. And then it essentially, therefore, has to be justified. And at the risk of criticizing the great Kalven Report, I would say this is maybe where it's weakest. And maybe it's because, as the report says in its kind of preambulatory paragraphs, it doesn't think of itself as breaking new ground. It thinks of itself as just embodying what is kind of obvious to everybody on the committee and steeped in the University of Chicago's tradition. And so if you get right down to it, what's the justification for this? It's essentially something along the lines of we cannot take collective action without inherently compromising the mission. And I think that I actually agree with that, but I think it's at least in the report itself, is exceptionally under-reasoned, under-explained, under-justified. I just don't think that's an a priori principle, that a university can't speak with a collective voice and still be a university. If Robbie were still here, I bet he'd disagree with me, but I don't find that self-evident, and I think to the extent that you believe in it, I think it's worth articulating and defending the position as opposed to just assuming everybody in the room already agrees with you. I think that this also has some interesting implications. As a constitutional lawyer, I'm fascinated above all else with structure. You know, it's one of the things that Supreme Court justices or constitutional lawyers will tell you, which is it's really easy to write a brilliant protection for rights, parchment protections for rights. But if you don't have a structure that makes it real and enforces it, then it really doesn't amount to much. And I think there are risks of that with the Kalven Report in terms of, is it just a statement of principle, or does it mean to have action? But I also think there are implications about the Kalven Report for how universities are structured. Robbie started off his remarks this morning by saying, you know, of course it would be wrong for the James Madison Institute to stake out a strong position on the Dobbs case. But to me, that's not obvious unless I know structurally exactly what is the James Madison Institute. Is it a component of the university? Is it an independent center? And should we take that into account? And obviously, these independent centers are proliferating at universities. But I do think the principles behind the Kalven Report have their greatest force when you are talking about the university. And maybe I'm wrong, but I think you could have the Kalven Report and still have an idea that an individual center is more like an individual professor. And so if we have two centers at the university taking different positions on the same issue, maybe we can tolerate that. But I think it comes down to structure. How do we conceptualize the structure of the university? And is there a difference between the government department taking a position and the Madison Institute taking a position and the Center for Something Else taking a position? And maybe not. Maybe people think that it necessarily encompasses everything, but that doesn't strike me as at all obvious. So if you think about the legal principles of all of this, another thought that comes to my mind is the great threat of the Kalven Report and its legal implications really has nothing to do with First Amendment principles. It probably has more to do with a risk of false advertising, which is to say, if you look at the Kalven principles and what they promise, and you look at what the universities actually deliver in practice, there seems to be a great chasm between the two, as far as I can tell. And I don't mean this so much at the level of, you know, a particular statement by a university administrator. I think the issue actually goes deeper than that. The thing about the Kalven Report that I find so refreshing, and part of the reason I count myself as a great proponent of it, but it says that the university experience is supposed to be upsetting. But how do you square that with the reality that so much of the current university seems designed to prevent students from being offended by things? I mean, those two don't go together. And there are costs of hypocrisy. And I think, you know, this is like I'm extrapolating a lot now, but the affirmative action case in front of the Supreme Court right now has almost everything to do with the Equal Protection Clause, and probably is decided by these justices the same way, no matter how the universities behave. But I actually think if the universities kind of took the Kalven Report a little more seriously, and the right side of the court didn't perceive the universities as being pretty leftist institutions that aren't kind of living up to their own institutions, in a sense, by kind of deviating from those principles, you're sort of making it easy on the court to look at the universities with great skepticism. And I love the Kalven Report because it kind of talks about that, which is to say, you can't just sort of take it for granted that everybody's going to hear you're a university and say, oh, you know, you have to earn it. And you have to earn it by honoring your principles. Otherwise, if you seem like you are skewed in favor of one political party or the other, it's just natural that the other party is not going to sort of honor the institution in the same way. And it's not going to respect what you're on about because it's going to watch what you're doing, and it's not necessarily going to see that you're honoring the own principles that you set forth. So I think that the costs of hypocrisy have real consequences, and they can change the way that cases are decided. Just two last observations, then I'll sit down. One is, I do think that in thinking about the challenges we face, I do think it's worth recognizing that we're operating in a broader environment that I think is tougher for the Kalven Report principles. Because maybe I'm naive about this. You know, I think I was born 1 year before the Kalven Report was issued. So I can't say like I can completely put myself back. And I know it was a time of tumult on the campuses, but I think in 1967, most corporate C-suites didn't think that they really should be weighing in on the war in Ukraine and the Dobbs case and on the gun case and on all these other things. And we're now in an institutional environment more broadly where a lot of the corporate C-suites, and Kalven talks a lot about acting in your corporate capacity. Well, the idea that like the corporation should just focus on the bottom line and not take political stands has vastly eroded in the ensuing 55 years. And so for a university to be true to the Kalven principles now, I actually think is a more radical proposition than it was at the time that it was originally issued. And so the last things I'll say is I just thought I'd finish by looking at the Kalven Report the way the lawyer looks at it. And first, if I look at it as a case, the way I read any case is if you really want to know what the case is about, look at the dissent. And so, you know, to me, the most interesting part of the Kalven Report is in some respects where Professor Stigler went in his dissenting opinion, and we talked about it this morning. But all the pressure, I think, really is, if there's going to be an exception, what is the scope of the exception? And then if you read it like a statute, which is the other way the lawyers like to read things, again, there's two pretty big exceptions. I mean, one's just a sub-manifestation of the other. But this kind of question, we talked about it, you know, there will come a time, we're not quite willing to state these principles boldly without exception. There will come a time, well, and, you know, we've heard differing views about when the time comes and what are the circumstances of that. And I just think if there's any effort to do a 2.0 report, there has to be a great deal of focus on the exceptions, because the exceptions will prove whether the rule is a good rule, it's a rule we can live with. And I just draw on, and we'll finish with this, just the one manifestation, one subclass of the sort of exception, and it was mentioned this morning as well. But this idea of, well, of course the university has to act differently. It comes within the exception when they do things like hand out honors and honorary degrees. It seems obvious, of course, that the university, qua university speaking, as if it were in its own government speech, is going to decide who gets that degree honoris causa or who gets this special award. But it's kind of a lot of trouble to not take any political positions on all the issues of the day and then give awards or give honorary degrees in ways that look to the outside world as being entirely political, entirely biased, and like you're taking sides. So I do think maybe it's impossible to stop to try to reform the honorary degree process or the honorary process, but if you don't do it, it's a pretty big exception. So anyways, those are some perspectives from the legal world.
All right, thank you. And I think there's going to be a little bit of overlap, and I'm going to try to answer some of the challenges that were just set out, or at least try to give a contour for how we might answer some of the challenges that have been set out. So I'd like to preface my remarks by saying that I'm not a lawyer, so despite being on a panel about the legal ramifications of the Kalven Report, I'm not a lawyer, I didn't go to law school, so I'm going to leave it to others to fill in those blanks and thereby try to avoid committing professional malpractice. Instead, it struck me that I might offer food for thought from my own field, which is business ethics, as well as adjacent fields that deal with questions of corporate personhood. So in particular, I would propose that one fertile avenue for discussion can be found in the scholarship dealing with the Supreme Court's 2010 Citizens United decision. And that controversial decision, if you'll recall, reversed federal law prohibiting, and here I'm quoting, prohibiting corporations and unions from using their general treasury funds to make independent expenditures for speech that is an electioneering communication or for speech that expressly advocates the election or defeat of a candidate. So I know what you might be thinking. Nonprofit universities, in virtue of their 501c3 status, are not allowed to engage in political advocacy for or against a candidate for office. Their activities are limited to nonpartisan efforts such as voter education, issue advocacy, and hosting candidate appearances. That being said, in business ethics and adjacent fields, there was an effort to think through not just whether the legal basis for the decision was correct, but how to think about the permissibility, that is, the rightness and wrongness of corporate political activity in the wake of the decision, with particular attention paid to the effects on liberal democracy of such activity. It's my contention that no matter whether you thought Citizens United was rightly or wrongly decided, the concerns that motivated this area of scholarship can illuminate our own discussions about institutional neutrality today. That is, regardless of where you land on Citizens United, by starting with the kinds of considerations that were most pressing to those writing about the decision, we can learn important lessons for how to approach the question of institutional neutrality. So, a central trend in the literature on Citizens United concerned the question of the decision's impact on the average citizen's role in the political process. Those who believed that Citizens United was wrongly decided argued that corporate money crowded out individual citizens' ability to participate in the political process. But proponents of the view that Citizens United was rightly decided also advanced arguments motivated by individual rights. Specifically, the proponents argued that Citizens United protected and enhanced freedom of association. In their view, it enabled the ability of individual citizens to promote the election or defeat of a particular candidate. Therefore, both camps shared a specific motivation, namely the decision's impact on the ability of the individual to participate in the political process. And I would argue that we ought to be motivated by similar concerns here. Namely, we should be concerned first and foremost with the effects of institutional neutrality on individuals' ability to partake in the ends of the university. However, this raises three questions. First, what is the end of the university? Second, which individuals in particular are entrusted with the execution of that end? And thirdly, does institutional neutrality inhibit or promote the individuals so entrusted? So let's take these questions in order. First, what is the end of the university? So this is obviously was a topic for discussion this morning, but I would propose the following formulation, that the end of the university is the cultivation of the habits of mind that lend themselves to the pursuit of truth and knowledge through the free exchange of ideas. So to be more precise, the ultimate end is the pursuit of truth and knowledge, and the means are the cultivation of the necessary habits of mind and the free exchange of ideas. So I'm sure some of you may want to add to that list of ends, but I do not think that any of those other ends supplant this as the primary foundational organizing principle of the university as an institution. Now, to the second question, to whom the execution of the end of the pursuit of truth and knowledge, to whom is that ultimately entrusted? That is, which individuals or set thereof are entrusted with the execution of that end. And I would argue, along with those scholars who drafted the Kalven Report, that the execution of the end of the university falls to two particular sets of individuals within the university, specifically faculty and students. They are the ones charged with cultivating the habits of mind necessary for the pursuit of truth and knowledge through the free exchange of ideas. Indeed, if it were otherwise, the presence of classrooms would be unnecessary, and it would be difficult to make sense of the many norms and expectations surrounding research. And for their part, the role of administrators is to run the university in a manner that's conducive to the execution of that end by faculty and students. So notice the subtlety here. The end of the university is the pursuit of truth and knowledge, but it is not the university itself that pursues truth and knowledge. That is, the messy work that goes into that pursuit, the reading, the writing, the discussion, and the argumentation, is not entrusted to the university qua corporate entity. If it were, then one might have an argument that institutional neutrality could thereby be abandoned, and its opposite, call it institutional partisanship, taken up. But that would be highly contentious and potentially mistaken, in no small part because such an argument relies on an assumption that universities are the kind of thing capable of pursuing truth and knowledge for themselves. And this, in turn, seems to rely on a conception of corporations as either natural or moral persons. And so I take it that not even proponents of the Citizens United were making the claim that corporations are natural persons, right? Instead, they focused their arguments on how corporate personhood as a legal convention enhanced or enabled individual rights, such as freedom of speech, or how it produced important social benefits that would otherwise be impossible or difficult to attain. And so for our purposes, since the debate on whether to adopt institutional neutrality does not turn on the question of a legal convention, Our task is to determine whether the university qua corporate entity is the kind of thing that's capable of pursuing truth and knowledge. And so to answer that, we would need to substantiate at least 4 claims. In other words, to make the case that the corporation is a moral agent relies on at least 4 sets of claims. And first, there would have to be something of an account given, about collective truth or a collective mind able to apprehend the truth. Second, one would have to specify how it could be held by a university and whether the university could hold such truths apart from whether a majority or even any of its members held those truths. Third, proponents of the view that universities ought to be able to engage in acts of institutional partisanship would also need to propose an argument for how the university either contains or could be redesigned to contain the organizational structure, policies, and procedures to be able to legitimately claim to speak on behalf of the collective community. Fourth, to qualify as the kind of agent that's capable of pursuing truth and legitimately making pronouncements with moral and political implications on behalf of the community. The corporate entity would need to be capable not just of intentionality, but of something resembling moral judgment. This, in turn, would entail corporations having at least some, if not all, of the following capacities: the capacity to form beliefs about right and wrong, the capacity to form corporate desires, aims, and commitments, the capacity to apply those desires, aims, or commitments to knowledge of its circumstances, in other words, a corporate capacity to engage in practical reasoning, the capacity to determine whether the results of having engaged in practical reasoning conform with its beliefs about right and wrong, the capacity to exercise self-control such that it can act on such determinations. So, for instance, the capacity to exercise, to refrain from acting when it deems that pursuing its commitments, aims, or desires in such and such a way would be wrong. There are likely other requirements too, such as the capacity to experience reactive attitudes, motivation, and moral emotion. This, I take it, constitutes a rather high burden of proof for the university. It may be a lower burden of proof for its units, but there's still a burden of proof that ought to be met. Even if such an argument were provided and proved conclusive, a further question remains: should the university act as an agent capable of the pursuit of truth and knowledge, or should it instead refrain and act as a forum for study, deliberation, and debate? And the answer here, I think, lies in determining whether acts of institutional partisanship or departures or exceptions to institutional neutrality inhibit the ability of the relevant individuals within the university to develop the requisite habits of mind to pursue truth and knowledge for themselves. So this brings us to a third question: does the adoption of institutional neutrality enable or inhibit the development of those requisite habits of mind? In other words, is there a good reason to believe that institutional neutrality is the appropriate ethical limit to impose on the university? And I would argue that it is indeed an appropriate ethical limit, for if we want students and faculty to form the habits of mind necessary to pursue truth and knowledge through the free exchange of ideas, a prerequisite for this is that they should be able to engage in the free exchange of ideas. However, departures from institutional neutrality by university administrators or even units within the university alienate students and faculty from their ability to do so. To understand why, consider what happens when administrators take a stand on an issue on behalf of the university or one of its units does so. Other individuals, namely students and faculty, are then prompted to interpret those positions as constituting a set of social norms to which they ought to conform, or as constituting beliefs and opinions that ought to be adopted, often because of fear of sanctions, social or otherwise. In this way, social pressure to conform to a set of norms or adopt a set of beliefs takes certain issues and questions off the table for faculty and students to consider and scrutinize for themselves through the free exchange of ideas. This, I would argue, is how we ought to understand chilling effects. The concern should not solely be understood in terms of self-censorship in response to social or administrative pressures. We also need to be worried about individuals adopting norms due to mere social conformity or compliance. When we understand chilling effects in this way, it's difficult to believe that departures from institutional neutrality would not thwart individual students and faculty's ability to pursue the end of the university. In summary, I think one of the most important takeaways is that we cannot escape the question of the end of the university. And Perhaps, there are legitimate ways of disagreeing about this end, but if we are going to add other ends to the end of the university, then we then have to give a sort of lexical priority about which end is really ultimately most important, right? Otherwise, we won't be able to resolve the question of, or the question of how we ought to consider exceptions. Thank you.
Good afternoon, everybody. I am so honored to participate in this really important conference. My panelists, co-panelists are so thought-provoking. I really can't wrap my mind around your very fast delivery, so I'd love written out versions if you could possibly share those. Although, Paul, I could see you were speaking without any notes in front of you. That was really an especially formidable performance. So I'm here. I'm not Greg Lukianoff. He's a dear friend and colleague, and I'm sorry to say he had a last-minute personal emergency, so I was happy that my schedule permitted me to step in for him. In fact, on my calendar, I had noted that this conference was taking place, and at the minute I had become aware of it a couple of months ago, I put it on my calendar, and I was planning on being here watching you all via streaming, so I'm especially happy to be here in person. I had almost no time to prepare remarks for a very good reason. I'm going to be narrating a 3-part PBS series about free speech and academic freedom, and I got the script last night, so I was editing that. Please forgive me, and I used the lunch period here to put my notes together for today. So I have just a few informal comments which are not necessarily focused on legal implications, so thank you, Paul, for covering that. I want to start with my own personal history with the Kalven principles because I think it really is indicative of the challenge we have to promote them. I have been very interested in and spending a lot of time studying and advocating and educating about free speech and academic freedom principles. I was intimately familiar with the Chicago principles from the moment they started to be drafted, but I had never even heard of the Kalven principles, or perhaps I had heard about them but completely forgotten about them until 2017 when my friend and colleague Jeff Stone, who's been mentioned here, was kindly editing a book I was writing about free speech and hate speech, and Jeff brought the Kalven principles to my attention. And I found them absolutely fascinating and compelling. Jeff himself has an extremely stringent interpretation of them, and one of the things that he shared with me, I looked it up, but I couldn't find it online. If any of you is interested, I've asked Jeff to forward it to me, and hopefully he will. You may recall a few years ago at Columbia University, some entity within the university, I believe it was the department, I don't think it matters who the inviter was, but somebody had invited Ahmadinejad from Iran to speak at Columbia, and there was, of course, the usual predictable controversy that the invitation should be completely withdrawn or the opposite, and the way I processed how Bollinger handled it, the president of the university, who's a very long-time colleague and friend of Jeff's. They have co-authored and co-edited countless books, but they very strongly disagreed about what transpired. Bollinger acted in his capacity as the president of the university in his formal role, acknowledging and introducing the speaker, and he then proceeded to denounce the speaker and his views very strongly. And some people thought that's not enough. Jeff thought that, and some people thought that was just right. Jeff thought that was too much and that it was inconsistent with the Kalven principles, and he wrote very strong op-ed, and I believe that Lee Bollinger might have responded to it. So that's kind of an interesting exchange about, as the report itself acknowledged, the Kalven Report. It's one thing to state abstract principles, but the devil is in the details, and even people who agree to the general principles will disagree about how they apply in particular circumstances. So in my exchanges with Jeff, when he first brought these to my attention, he had such a strong view of them, answering your point, Paul, about how they are implicitly required as an essential prerequisite for robust academic freedom. In other words, there's going to be such a chilling impact if the university doesn't adhere to them, that I actually was prompted to ask Jeff in response to these strong points he was making, well, would you actually contend that at a public university, these are legally required under the First Amendment? The First Amendment, of course, prohibits any abridgment of free speech, and the Supreme Court has interpreted that term very functionally and practically, asking so that it can go way beyond a formal law or a formal court order. The court has asked, I think quite correctly, whether as a practical matter the government action in question would have a sufficiently deterrent or chilling impact on a reasonable person, and that it should be considered to be an abridgment. And again, reasonable people could differ. Jeff never answered that question. Paul, I gather from what you said that you would give a definitive no to that question, but I think it's a question worth entertaining, and at least, as you say, we should flesh out the argument. How chilling is this? And Paul, you also mentioned the corporate world and the former distinction between the corporate world and the university world. I have started to see trends on the part of some corporations and businesses to try to move toward something like the Kalven principles, with very mixed results. Rosemarie's nodding her head, with some great applause and apparent success and some real pushback. I wanted, in addition to the First Amendment free speech kinds of benefits, academic freedom benefits of the Kalven principles, I want to mention one other really important civil liberties and constitutional law concern that is bound up with these principles, and that is due process, fundamental fairness, because when the universities, the presidents, the provosts, and so forth, come under and succumb to enormous pressures to very quickly denounce in the strongest possible terms any kind of speech or speaker that is detested by pressure groups, what we see is a denial of the most basic due process principles, starting with the presumption of innocence and moving on to an opportunity to know the charges against yourself and to defend them. We've over and over again seen a pattern of first of all, to accept, apparently without much analysis or investigation, the critics' strongest, often distorted, exaggerated, hyperbolic version of what allegedly was said, and then to denounce that in the strongest terms, and perhaps even to punish at that point, right, to suspend the faculty member, and then to conduct an investigation. And by the way, the investigation itself is a form of punishment. So one of the other really important advantages of acknowledging and adhering to the Kalven principles would be to restore due process on campus as well as free speech. The next point I'd like to address was Rick Schwader's really helpful answer to my question about how do we enforce these principles? Should we enforce these principles? And that was also addressed by other speakers subsequently, including Paul. One possibility, it seems to me, would be what we lawyers have in our Code of Professional Conduct, and that is, in addition to actual enforceable rules that are subject to sanction for violation, there are also standards of aspiration that are taken very seriously, but that are not subject to regulatory, judicial type enforcement. And it seems to me that something like that could offer a middle ground between two extremes that neither one of which would probably be desirable, I think. On the one hand, rigidly enforced regulation. Rick did not support that. I don't support that. It could do more harm than good. On the other hand, to essentially leave them as parchment barriers, to quote our hero James Madison, between academic freedom and the opposite is also not desirable. But if we have this middle ground of they are taken seriously enough that we at least have to discuss them. And thanks to the 50 at the University of Chicago who are already doing that. And that apparently was taken as the original intent of Harry Kalven himself, according to his son, Jamie. I read a really interesting article in the Chicago Maroon, which I believe is the student newspaper, right, from a couple of years ago. It was an interview of Jamie Kalven, as many of you may know, and I think it's already been referenced. He was a great scholar of his father's work and spent 10 years of his own life completing his father's major First Amendment tome, among other things. And this article is headlined, "The Kalven Report, a discussion, not a law." It quotes Jamie Kalven talking about, what his father's intent was here. He said, "My father," and he's referring to the First Amendment, but he's also referring to the Kalven principles. "My father's position was that the First Amendment is almost an absolute, but everything hinges on that almost," right? We have to be prepared to have that argument again and again. So I would apply this to, John, what you called the clause, right, and the exceptional clause here. We have to be prepared to have that argument again and again in each situation, and that's a good thing, Jamie Kalven said. If it's an absolute, people just sort of apply it reflexively, thoughtlessly, and don't even really grapple generation to generation with the nature of the principle. So in some ways, you're embodying the whole process and function and spirit of academic freedom by going through that process. At the very least, any exception would have to be rationalized, and we might even want to ratchet it up one level and say, in addition to a discussion every time an exception is invoked, that there would have to be a written rationale, similar to the way judges have to go through the disciplinary process of writing an opinion. And I remember a famous situation in which Justice Kennedy, with admirable candor, had voted one way after one of Paul's brilliant arguments, voted his way, of course. And I'm just joking. I'm not sure it was one of your cases. And was starting to write, he was assigned to write the majority opinion, and he struggled with it. And then ultimately he said it just would not write itself. And I really appreciated that. It's a great role model for us in the academy, right, that judges have to go through to admit when they have, and I shouldn't even use the word admit, to acknowledge when, as a result of thinking rigorously and trying to defend their conclusion, guess what? They changed their minds. That's really a terrific model. So we could impose that kind of minimal procedural requirement for an exception that could well end up having substantive implications. As people re-examine, they might reconsider whether the exception is warranted. The next point I wanted to address was Stanley Katz, who said, well, it's one thing to have a principle, but it's another thing to apply it in the real world, bringing up the very pragmatic concerns here. And I've always been mystified as to why university so-called leaders, forgive me, why those who occupy leadership positions in universities do not welcome this approach from a pragmatic and strategic perspective. It seems to me it would make their lives so much easier, not only in dealing with particular controversies, but in warding off future controversies. The Chronicle of Higher Education did a very interesting survey of university presidents published, I think, toward the end of the summer, in which, not surprisingly, the university presidents were complaining about what a time drain it is, what a resource and attention drain it is, that they're constantly being asked to issue more and more public statements about more and more public controversies. So wouldn't they leap at the opportunity to say, no, that's none of my business. I've got to attend to other things that have to do with the mission of the university. My observation, anecdotally, and it's shared by my colleagues at FIRE, I'd be very curious to hear from folks on the ground, such as those at the University of Chicago, but our anecdotal observations seem to indicate that when presidents and other leaders do take a firm position, such as what Robert Zimmer took in the Dorian Abbott situation, as Rick described this morning, that the controversy goes away because there's no fuel to feed it anymore. And I have asked a couple of friends at UC, and they say that, including Dorian himself, that the controversy did seem to go away fairly quickly, whereas when presidents do issue a statement, do issue an apology, do announce that there's going to be some investigation, that only is like, throwing fuel on the fire, and the demands then become ratcheted up. The apology isn't strong enough, the condemnation isn't strong enough, and what's more, once the statement has been issued in one situation, there's no stopping point because, not to issue it in another situation creates what we lawyers call a negative pregnant, an implication that you are, in fact, endorsing whatever you don't criticize. And I was reading something recently that was talking about President Lowell at Harvard, of whom I had a very negative view for various reasons, including implementing the Jewish quota. But, you have to judge each action, right? And he apparently did at least one positive thing in terms of academic freedom. He issued a very strong statement in which he refused to condemn or to censor some controversial expression. I believe it was by a professor. It was for a very pragmatic reason. He said, if I do that, then every time I don't do it, I will be seen as endorsing. And I can't be in the business of having to review everything that's said by every faculty member for fear of otherwise being taken to endorse what they say if I don't do the opposite. I do think, in the positive vein, while I think university leaders should not issue these quick condemnatory statements, it is appropriate for them to reiterate their own institutional policies if those policies are relevant. In many situations, what the speaker says may have nothing to do with a university policy, but it happened that it did in the Dorian Abbott situation because he was talking about DEI, and the university does have a DEI policy, and so Zimmer just very quickly reaffirmed the university's own position, but he did it, as Rick mentioned, without even mentioning Abbott's name or referring to his expression, let alone condemning it. And moreover, it was a statement that referred to the university's support of diversity, not only in terms of identity, but also in terms of ideas and perspectives. So it was very doubly good from an academic freedom point of view. Now, there are a couple other strategic advantages when university leaders follow this approach rather than the naming, shaming, and blaming that we too often see. And the other advantages are specifically from the perspective of those who object to the controversial statement. Number one, when the university president just says, you know, this is free speech, intellectual freedom, and we're not going to condemn it, that reduces the attention to it, especially when you don't even mention the statement or the name of the professor. And as we all know, people seem to keep constantly overlooking this lesson, but the more you protest, the more you try to suppress, the more the forbidden fruits phenomenon comes into play, and you end up amplifying the very message that you're seeking to suppress. So the Kalven approach undoes that forbidden fruit tendency. And also, for those who are actually interested in trying to change hearts and minds, maybe not necessarily of the speaker himself or herself, but at least of people who are listening, paying attention, trying to make up their own minds, it is not a particularly effective persuasive strategy to get into the naming and shaming business, and those who do generously devote their lives to trying to redeem people away from hateful or discriminatory or other damaging views are the very ones who say, you know, if you really do want to change people's hearts and minds, you can't call them out, you have to call them in. I'm quoting Loretta Ross, a radical black feminist who has spoken and written eloquently about that. So again, I'm just honored to participate in this process, and I can't thank the Madison Program too much for breathing new life into such important principles.
All right, so thank you very much. I was going to claim a moderator's privilege to ask the question to the panel, but in the interest of time, let me open it up to y'all instead and make sure we get your questions on the table. There's a hand right there.
Thanks. Arch Davis, an alum here. Is this on?
I think it's on.
I got up this morning, I woke up and I realized that there's no God, and Karl Marx is his prophet. Nobody ever gives a definition of what woke means. So now you have one. But I spent 6 years of my time working with Ernest Gordon, who was dean of the chapel here for 25 years. Many years ago. He's passed away. Very interesting guy. He spent 4 years of his life in a prisoner of war camp, forced labor camp in Thailand, courtesy of the Japanese conquerors. And he had some interesting perspectives. One of them is that there's no such thing as objectivity. He said a professor professes a philosophy, and you expect that. And you expect a faculty member to be to have an opinion and to speak from that opinion. But that I haven't heard a lot about that today. But that seems to me it's not the Kalven principle. Maybe it's a Luther or Zwingli. I don't know, but. One final thought is that, speaking of reformers, there's Thomas Aquinas, and at some point in his life, apparently, he just realized something that was beyond all the scholarship that he did, and or could be said about that, which I can't right now. But maybe sometimes just the principles we have aren't everything, and you have to transcend them in some way.
Any thoughts or reactions to that? No. I think there's a hand over here.
Hi, thank you so much for your time today. I was wondering about the practical working definition of a statement in the modern era. It seems as though universities can issue an informal statement through newsletters or social media posts or through emails, or the dean emails the entire department. At a more niche level, in the women's bathroom, there's a sign that says, like, be a good bystander. Then there's also a sign on, like, how to wash your hands well. And so I'm sort of wondering, like, how niche is, and, like, how specific is the definition of a statement, and how is it practically applied throughout the university?
So what constitutes a statement under the Kalven principles?
I don't know under the Kalven principles, but I would say a general legal interpretation. I defer to my other fellow lawyer on this panel, but I would say what a reasonable observer, that's a formulation the Supreme Court often uses, would ascribe to the university. And the Supreme Court has used that test in the context of the First Amendment Establishment Clause, where the question is, the question used to be, would a certain religious expression in the public sphere be seen as government sponsored, or should it instead be seen as just a private person who happens to be expressing his or their religious beliefs? And in that context, as well as others, the court has posited, and we have that in other areas of law as well, the concept of the reasonable person. And the examples that you gave, Abby, I think would all be seen as university statements, unless unless there was some indication to the contrary, that it's just coming from a student group, for example.
Yeah, I mean, I would say, I think I agree with everything you said. I would just say, I think it's a great question because it points out that, the Kalven statement has to, I think, at least classically, you think about it being, the university president speaking on behalf of the university condemns this or that atrocity. And I suppose if you think about, the statement being, the university condemns not washing your hands. I mean, one way of thinking about that is, well, that's captured by the principle, and maybe we need a broader exception than we thought we did. Or maybe we need a better definition of statement. And I think that's maybe what your question really gets at, and I think that's important. But then I also think this is a little bit where I was going with the honorary degrees and stuff. If you go to all the trouble of having like a very kind of institutional neutrality policy, and then you get an alumni magazine that's going to turn off like 35% of the alumni who don't agree with the editors of the magazine on everything, on every political issue, but it purports to be the university's kind of alumni magazine. I mean, that's a pretty big problem, I think, for the idea that the institution as a whole is going to have a position of neutrality.
I can just add also on that question about, it's a question about voice and authority. And the article that I mentioned, Reading on the Train, is really useful on that. It has a great little section on that. And again, the title of the article is Harry Kalven, Institutional Neutrality and the Charisma of the First Amendment. I highly recommend you read it.
This was from the Princeton alumni free speech.
The author's sitting right up. I'm embarrassed because the author's sitting right here. But, yes. But it goes directly to your point, and it answers it nicely.
So can I build on that for a second, though, this question of what constitutes a statement from the institution, and so it goes to one of the things I was going to ask earlier. So is it possible for a president of a university, for example, to ever speak in his personal capacity? So there was to take Brown University, there was a huge national controversy at the end of the 19th century around the president of Brown University, who almost got himself fired because he was a big free silver advocate at the time in which this was a hot political question. This arose out of his own scholarly work before he became president of the university. But the trustees, unsurprisingly, not free silver advocates themselves, and thought that the president of the university speaking out on free silver in the late 19th century was a good reason to fire the president of the university. And the division of argument about this often turned on if this should be couched as it was his academic freedom as an individual and as a scholar to be able to express his personal opinions about free silver, or whenever he spoke, he always spoke as the president of Brown University. And those who wanted to defend his right to speak wanted to characterize him as speaking in his personal capacity. Others said it's not possible for him to speak in his personal capacity. So under what circumstances can a president of a university plausibly say, I'm speaking in my personal capacity here, this does not reflect the institutional view of Princeton University as such?
Yeah, no, I think it's a good question. I think one way to look at answering it would be, is the president of the university leveraging any privileges that come with his or her role to get the message out or to offer legitimacy to that message? And if so, then I would say if you're using your role, then you're not speaking in your personal capacity, right? So I think there may be markers like that that we could look for to make that determination.
I personally had to grapple with something analogous when I was president of the ACLU, and I hate to shock people, but I didn't agree with 100% of decisions that my board of directors made on contested civil liberties issues. And my own view, it wasn't a rule, but my view was that when your position is that high, president or executive director or legal director, whatever you say is going to be seen as reflecting or even having an adverse impact on if you're criticizing what your organization is doing. But whereas, and this is important that I took that position at the ACLU because we so strongly defend freedom of speech for our employees. I'm constantly having to explain why we allow individual employees to send out tweets denouncing ACLU positions. I get asked about that all the time. They say I'm speaking in my own capacity, not on behalf of the organization. But when the person is high enough in the organizational structure, I think that's, as a practical matter, impossible to make that distinction.
On the narrower point of silver, I'll just mention that a couple years ago, Brown bought Bitcoin. Whether we got out, I'm not sure, but I believe Princeton got in too about 3 years ago.
Yeah, and I would just add, I think, in some ways the practical answer was, would anybody care what you're saying if you weren't the university president? And I think most of the time the answer is going to be no. But, I would distinguish between a university, if a university president speaks in his or her personal capacity about the war in Ukraine, the only thing I'd want to know is, before you were university president, were you a sort of professor of, sort of Ukrainian studies? And in which case, okay, you should be able to speak about that in your personal capacity. But otherwise, probably not.
Good afternoon. My name is Brian Paul. I am with the American Council of Trustees and Alumni, ACTA, in D.C. My question goes to Dr. Monge, referenced during her remarks, but is open to anyone on the panel who wishes to respond. I was intrigued by what you said, or the question you posed: should the university act as an agent or a forum for free expression and debate? I wondered whether we might be able to probe that a little more and just better understand, what do we mean by a university acting as an agent versus the forum for free expression and debate, and what are the legal implications for being one or the other?
Yeah, so I think one way to think about it is that we're ascribing a sort of collective mind to the institution, or a collective ability to intend certain things, make moral judgments about certain things. So that is how traditionally people have thought about corporate agency, is either, for instance, intention, the capacity for moral judgment, the capacity for moral emotion, the capacity for rational deliberation, but on the collective level rather than on the individual level. So that's at least for those who have written in the field, those are the sort of markers that they've looked for when they look for what it means to be a collective agent, or a corporate agent, rather.
And I think running the Kalven line, the straight down the middle Kalven Report would say a university is a forum or a platform.
Yeah.
So Bernard Hakel here again. I just wanted to go back to the earlier question about, who speaks and how does that speech, what form does it take? So let me give you 3 examples from from Princeton University, recent examples. So here we have a School for International Affairs whose dean put out a statement about the Carl Rittenhouse case in her capacity as dean. We have another case where a department decided to put on its website, in the name of the department, a statement condemning one of its faculty for having written an article that they disapproved of, and essentially depicted him as a racist. The third instance of the institution taking a position, which is not the dean, dean level or departmental level, is at sort of the university level, the highest level, and that's when the university president appoints a committee, as it did recently, to decide on whether the university should dissociate itself from the fossil fuel industry. This committee was constituted, and the decision was taken to dissociate. A lot of the faculty told me who are taking money from the fossil fuel industry, incidentally, most of them to mitigate carbon emissions, not actually to promote the bad side of the fossil fuel industry, were very upset about this because they claimed they were not consulted. But the university, in a sense, created this committee, gave the decision a form of having been deliberative, and then a decision was taken to do so. So those are three different ways in which that are recent examples from here about how the university takes a position, and in each case, I think, violated the Kalven principles, and chilled speech. I still don't fully understand why, just going back to the point that that Nadine made, which is that this university in particular, but I think most universities are not democracies. They're typically much more autocratic in their decision-making structures. Why they would not want the Kalven principles to be applied, because that gives the autocrat protection from different constituencies. But I mean, I see your head is shaking, so I would love to hear your views on all of this.
Well, I'll just say one. Oh, sorry, I'll say two things. I was playing around this morning with the idea that someone just floated that maybe we should allow, maybe in a free university committed to knowledge seeking first and foremost, we should allow sort of polycentric speaking. Department heads, chairman, this and that kind of speaking along with everyone else. We kind of have a rich, more speech kind of approach. And Nadine and I kind of smiled at each other. But now I think that's probably wrong. If you think about it, right? The chilling effect that Kalven describes is now more localized. It's more brought home. It's someone involved, your department chair, as to say, in your raise, right, in your promotion. So there's actually, I think it's worse to have a plurality, a polycentric speaking thing. On the narrower point that you asked about precedent, and this goes to Nadine as well. I've spoken with, I think 4 presidents in the last few months who said to me this interesting thing about speech, about their speech. They said that, off the record, so I'm not naming them, they said to me that when they talk to public relations firms, as presidents actually sometimes do, one of the pieces of advice they get is that it's better to be out in front of an issue than behind it. So speaking out is often a kind of insulation for stability in the institution. And again, I've got this from several presidents in a row. Now, maybe you can have a culture in which the president just says, I never speak. And they face the dilemmas exactly you guys have been saying. Once you do it, you got to keep doing it. And why didn't you do it? So there's vulnerability with this approach. But there's a reason why they sometimes do this.
So I have a question. I guess it's a follow-up to a question I asked you, Nadine, last week. One of the main issues with the Kalven Report that has kept me from, signing on to it 100% is the issue of discerning precisely when an issue is so tangible, bears so tangibly on the functioning of a university such that it would be appropriate for universities to take positions. You suggested last week, my question was about where do you draw the line? How do you discern those cases? So for example, a university could take a position on wealth inequality, which, because wealth correlates to, opportunity and opportunity to admissions or something like that. I mean, I don't buy that, but that's an argument that could be made. So how the line is drawn, I'm wondering if any of you have a test in mind, maybe something like the Lemon test, the reasonable observer test, although that's no longer good law. I'd be curious to hear your thoughts on that.
I think that the critical exact language for the textualists among us, it can be read quite stringently. From time to time, instances will arise in which the society or segments of it threatens the very mission of the university and its values of free inquiry, which you can even read that two ways. It could mean only that the value of free inquiry is the special mission of the university. On the other hand, that pesky word "and" suggests that there might be some other concepts of the mission of the university. And it uses the word crisis in the next sentence, in such a crisis, suggesting that this would be rather extraordinary. And then there's the other situation where the corporate interests.
Yeah, and I would just add two things. First, I love Nadine's idea of, sort of a forced dissent or a forced opinion whenever you take advantage of the exception clause. I mean, I think that, that's a healthy sort of procedural, I think, constraint, that the default is the Kalven principles. If you stick with the principles and don't invoke the exception, you don't have to explain yourself. The report explains itself for you. But if you want to invoke the exception, then you have to. But then, I guess my other thought on this is, this is where I think the original justification for the main rule is a little it's a little more ipsit dixit than I'd like, and a little bit less explained. But the idea behind it is that it is really inherent that just speaking out on issues generally in a corporate capacity is inconsistent with the mission. And then the exception talks in terms that are more sort of existential and a necessary exception to that. And so I think one way to think about it is, if it's really in the exception, then what you're really saying is that is an issue that is so antithetical to the university that we're not worried about chilling speech on that issue. We actually want to kind of eradicate the contrary view. And we're okay with that. We're willing to live with that consequence. But that seems like it's sort of what it's getting at. Because if the idea is that, generally speaking, corporate speech on behalf of the university is just antithetical to the mission of the university, but there are some situations limited that are, where the speech really threatens the whole university, then it's almost not enough to just speak out on the subject. You really ought to kind of, throw all your force behind that. And I think if you thought about it in those terms, like, wealth inequality might be a problem, but I don't think you're really willing to sort of just say that the whole issue is kind of taboo. So you should be kind of staying away from it as the exception.
Oh, that's so interesting. For those who don't have the language in front of you, Paul is referring to the next sentence, which can actually be seen as imposing another limitation on how you interpret the first sentence, because it says, in such a crisis, another one where, in other words, where the mission of the university is threatened, in such a crisis, and John obviously talked about this as well, it becomes the obligation of the university as an institution to oppose such measures and actively to defend its interests and values. So you're saying, unless you would be willing to do all of that, you can't even make a statement.
And sometimes you must.
Yeah.
You, Paul, who I admire so much, said one thing twice I just need to address, the ipsit dixit point. I think I would describe the justification for the Kalven principles as brief, but not in the sense of being underworked. I think they're brief in the sense of being efficient and compact. I find the formulation, although brief, enormously deep. And one sign of the depth of the account given for the Kalven principle is that the structure of the principle and the exception, and as you say, We often learn about, we study the exception to learn the rule. The structure, the conceptual structure is the Calvin principle and the Calvin clause, as I'm calling it, are both justified by the same conception, the same brief argument, the idea that the university's purpose is to be a knowledge-seeking organization. If you check out the text carefully, both of those claims are rooted in that same idea. That is an extraordinarily compact and I think kind of an almost brilliant way of structurally justifying something. I'm not saying it's not perfect. I always love more reasons too. I'm giving better, fuller justifications, but I think it's worth noticing that the exception and the rule come from the same root principle.
We're pushing time, but maybe one more quick question.
So, two quick observations and one question. The Kalven Report is 1967. It was not until 2 years ago that the university took the position and made it explicit that the institutional neutrality principle applied to all units of the university and to anyone who was in an administrative capacity, that is, had been officially appointed as an administrator like chair or head of a center or so forth. This is at Chicago. I mean, so I had been writing actually to the central administration about messages I was getting from various centers which looked highly political to me, but there had been no statement of that until 2 years ago when we had these websites going up and some protests. And I think it's interesting to think about how we got along since 1967 with everyone thinking it was the Board of Trustees should denounce the war in Vietnam or whatever. It was at a different level. Second observation is the University of Chicago has always, for a long time, had very prominent schools of thought. The Chicago School of Economics, the Chicago School of Anthropology. These were organized around dogmas of various types, but nobody really thought that was a violation of Calvin. And I can easily see someone saying, what do you mean? Look, these are institutional positions, but how one distinguishes the evolution of a school of thought with a very clear ideology behind it from an institutional statement, it seems to me, is something we need to think about. The question I have is this historical shift in corporations, non-academic corporations. What led to corporations abandoning a neutrality position and becoming so much more outspoken? Was it concerns about their own employees and their political beliefs and keeping people on board? Was it market effects? They thought the bottom line was going to look better if they did virtue signaling of various kinds. Because it strikes me that in and of itself needs to be explained, and I don't have an answer, but I'd be certainly curious if any of you do.
I'd love to hear what Paul has to say about that because he brought it up. And we might throw into the hopper law firms, I dare say, are issuing more of these statements.
Yeah, well, Rosemarie might actually have the answer. I mean, I think in a lot of these things, it's law firms, academic institutions, sort of businesses. I think that there is a principle that should work against that. And I think in the context of academia and law firms, it's a principle that sort of, pretty close to the core of what makes it a profession rather than a business. So I think there's like a separate case from the businesses would be my view. And I think what you're sort of seeing is just kind of an erosion of that principle. That's certainly what I think is happening in the law firms, where the sort of idea that, like, look, we don't criticize us about our clients. We're in the business of representing unpopular people, and that's a trend line that goes back to John Adams. And just if you're criticizing us for the nature of our clients, you're not understanding what we're on about. And I sort of feel like in academia, there's the same principle, which is that, reflected in the Kalven Report, which is the idea that if you're asking us to weigh in on these issues at sort of the institutional level, you're sort of missing the point of what this institution is all about. I think in the business context, I don't think, business doesn't purport to be a profession. I guess they're refreshing in that way in some respects, but there still is this kind of notion that, like, look, the function of the C-suite is to maximize shareholder value. On any given Tuesday, half of our shareholders are Republicans, half of them are Democrats. Let's stay out of politics. It's bad for business. And that's no longer the view. Now, that's where Rosemarie is going to tell us why.
So I do have some thoughts about this. So I think one of them precisely has been a pushback against shareholder primacy. So I think that's one of the causal reasons that people have wanted to ascribe to corporations more than just one ethical obligation. That one ethical obligation that they were pushing back against was the principle that there's only one social responsibility of corporations, which is to maximize shareholder profits. So but in order to push back on that, I think what they introduced was this conception of corporate social responsibility, which is really amorphous. So instead of thinking clearly about what the ethical limits to profit seeking might be, we decided, or not we, like, in general, we decided that corporate social responsibility and the language and the slogan around corporate social responsibility kind of took on a life of its own, and then a whole host of obligations were foisted on corporations, and it was never quite clear to me what the prioritization of those obligations was supposed to be. And so I really think that rhetoric then was taught to business students and taught more generally, and I think the general public has now, or at least I believe executives believe that the general public expects them to take on all of these obligations, and that all of these obligations are sort of equally important. And I think that's actually a mistake, right? I think we can say there are ethical limitations to profit seeking without then throwing all sorts of social obligations on the shoulders of corporations without making distinctions or prioritizations with respect to those obligations.
Okay, so that brings our session to a close. I thank you for joining us for what was a very interesting panel. And I very much appreciate our panelists. Thank you.